As you know, I'm based in Ontario. So a lot of the changes I'm talking about are specific changes that Ontario has made to the Employment Standards Act. Those of you who are in a workplace that's over 25, you're probably already compliant. But let's just go through some of those changes because there's a lot of work there.
Workplace law is complex and constantly changing. It can be hard to keep up, and the risk of getting it wrong can be costly for businesses. The Coffee and Law podcast is here to help HR professionals and employers stay informed. We'll cover what's changing and how to navigate real workplace situations and everyday people decisions. So grab your favorite warm drink and join us for engaging, practical, and educational conversations with top experts in workplace and employment law.
This podcast provides high-level general information. The perspectives shared by our guests are for educational purposes and do not constitute legal advice. If you have a specific question or concern, please consult a qualified lawyer.
Well, hello, everyone. I am thrilled for the launch of our Coffee and Law podcast. And I've got Neena Gupta with me here, Neena, I thought we should share for just 1 or 2 minutes what happened, how we came together, why we started the show. So I'll tell from my perspective, and then let's hear from you. I'm Amy Davies. For anyone who doesn't know me, I run a business called First 30. And I saw Neena quoted in an article years ago during COVID and reached out to her on LinkedIn. And I thought, there's no way. She's too important. She's a partner at Gowling WLG. She's got more important things to do than to respond to Amy Davies. And lo and behold, she responded within minutes, Neena. And then I invited her to come start doing webinars with me, and they have just grown and grown and grown. We get hundreds of people registering for every one. And then I said, hey, let's do a podcast. And so here we are. So Neena, do you have a different version of
No, I don't have a
events?
different version, but I remember this very clearly because you reached out with respect to that whole controversy of vaccine mandates in the workplace and how do you handle that? And we had published something about that and I had posted it and you reached out and we had a LinkedIn chat to start with.
Yes.
And you have to understand lawyers are typically employment lawyers are definitely people lawyers. And the whole 2020, where we had just gone 100% remote, working from our different offices, never really getting any feedback as to whether our advice or our bulletins were of any use. It was just such a joy to get this cheerful note via LinkedIn. And so we started talking. And I have to admit, I'm not as technologically savvy as Amy is, but she was the one who said, well, we should be doing webinars and we should be doing podcasts. And I started thinking, you know what, where Amy leads, I will follow. How's that? That's my
that
version
is
of
nice.
the story.
Yes. Well, thank you for saying that. I think we both brought a lot to the table. So I am just so happy we're doing this. And today we're going to talk about, the thing that I love about doing the show, and I say it in the intro, is that employment law is complex and it's always changing. And it is so hard to stay on top of everything. When we look at employers and when we look at HR, they have so much going on and so much they're responsible for. And we can't forget the people element of it all. Schedules aren't predictable. So I think it's a really good to have a place to come to keep up, right, with everything and get really great advice from top experts. So today we're going to be talking about what you need to be kind of aware of for 2026, what is changing. And Neena's going to help you by understanding how to contact her if you need legal advice. We do say in the intro that, this isn't legal advice, it's a perspective. And if you want legal advice, you can definitely reach out to Neena, look her up at Gowling WLG or like I did on LinkedIn. But let's go. What are we talking about today, Neena?
Well, as you know, I'm based in Ontario. So a lot of the changes I'm talking about are specific changes that Ontario has made to the Employment Standards Act. And those of you who are in a workplace that's over 25, you're probably already compliant. But let's just go through some of those changes because there's a lot of work there. the first biggest change is how you recruit. What I mean by that is if you're putting ads, on Indeed, on your careers website, and maybe some of you still advertise in the local newspaper, you have to advertise the range for your jobs. Now, the range cannot be more than 50,000. Some people say, well, I'll just put a $500,000 range and then I'm not really disclosing. No, you can't do that. It's got to be a realistic range given what you know about what you're willing to pay for this type of position. You have to let people know whether it's an actual position or are you just kind of seeing what's out there. You're tentatively thinking, maybe I'm going to hire somebody. Let's see who's out there. You've got to, talk about whether it's an existing vacancy or a new vacancy. And then finally, whether or not you're using AI in any way. And that one I'm encouraging people to be really diligent about because some of the tools that we're already using through third-party services may be using AI in the background. And so how are you going to use AI? How and those are major changes if you haven't been thinking about them throughout 2025.
Yeah, and Neena, I have some questions. So can you just remind us, when does this take effect or has it already taken effect?
January 1, 2026. So,
oh my gosh. So we've arrived. And the thing that I think people will be taking notice of is this is a really easy one if someone's going to report you to prove that
Right.
it is true, right? So I'm interested now. I want to start looking at some job ads, but what are you actually seeing out there right now? Are companies compliant from what you can tell?
So I'm very pleased to say that particularly with the slightly larger companies that are hiring externally recruiting, they're certainly compliant with the job range. They'll provide a hourly or salaried expectation. There is an exception for what I would call a higher um, salaried individuals where the total compensation is expected to be about 200,000 or more. You don't have to provide a range, but I am seeing compliance on that salary grid. Where I'm not 100% certain is whether people are actually realizing how much AI has infiltrated. And I don't mean anything negative about that, some of the standard tools that you're using. So I just think that, a short AI is used to help prioritize or sort or, review applications if that's what you're doing. And then my smaller companies that, that are doing things more old fashioned and they're usually below 25 people, so I don't worry about them. But I think people have tried, and I'll tell you why. It's because BC was first off the bat. So many of the national companies are kind of used to doing some of this because they've been doing it in British Columbia.
So if I'm using AI to say I'm leaning on ChatGPT to help me write the job ad, does that qualify?
No, it's more whether you're using it in the selection process. So
Sure.
I'm not suggesting anyone should do this, but let's say you got 20 resumes and you threw that in the job ad and asked ChatGPT to rank them. That's an obvious use of AI.
Yeah.
Right.
Yeah. And I just wanted to add here, it's so important. I'm sure we're all singing from the same song sheet here, but if you put people's personal information on ChatGPT or on any AI, into any AI system, it should be one that's closed, that you are actually paying for, because there's so much that's free out there. But when it's free, you're putting it out into the universe. When it's paid, it's closed AI, so it's not being shared externally.
Yeah, and that's a really good reminder because it's so easy to say, "Oh, ChatGPT will do this for me," right? The other change, and I know this sounds like it's so annoying, but there's a document retention requirement now when we're recruiting. So essentially, and you'll have to look into it as to how it applies, but essentially, we have to keep our recruitment effort, all our communications with candidates and their communications back with us for a period of 3 years. Now, if you're
This is one that scares me
I
so
know.
much. Neena, we talked about this on our last webinar, and oh my gosh, it just filled me with chills because you absolutely know that some of these, there will be cases brought over hiring, and the expectation on a company is there's a lot that is expected now. And if you're not, if you haven't complied with the law, you're putting yourself at risk.
Right. So the desire, I think, from the Employment Standards Act was to make sure that you were, in fact, complying with the document like the advertisements, communications with clients. There's another requirement that if there's a candidate and you've talked to them about an interview, you have to tell them within 45 days whether or not the position's been filled, whether or not you've canceled the posting, whether or not you've gone with another candidate, whether it's still ongoing, so on and so forth. So the 3-year requirement was really designed so that the Ministry of Labor could audit compliance. But that same documentation could be demanded if somebody says, you didn't hire me because I'm a female, I'm an ethnic minority. Well, then they can say, well, and you hired somebody who was less competent. And if you don't retain those records, it's very hard to prove that you had a fair and transparent process. One other word, Amy, and we talked about this offline, was what if you're like a company in my neighborhood that's constantly looking for general labor? Right? Constantly recruiting. Well, what I'm recommending is that you post the ad and you have a date on which the ad expires, and you keep the communications relating to that 30 or 60-day period in one digital file. You then repost the ad. Let's say we're going to do it on March 1st. And you have it expire May 31st, you will keep that, you will count that 3-year period from May 31st, so that you have essentially the same ad, general labor, maybe general night labor, but you don't have an infinite document retention requirement because you're essentially artificially ending at the particular ad's expiry date. You're going to put it in, and then you're going to start a new ad, and you're going to keep that for 3 years, and so on and so forth. And I don't know that the government really thought that through, that there are certain jobs, we're not all doing one specific one-off position. There are industries that are constantly recruiting, and how are they going to comply?
And here's the thing, you talked earlier about my tech savvy. I actually don't know exactly how the systems, say an HRIS, will retain records when there's the interview process. But what I would encourage our audience to do is look into tech solutions, because there's just no way that you're going to be able to do this on your own. You can probably set dates. And if one doesn't exist, Neena, I'm going to create it. Because it's going to be game changing for organizations to have that. The other little piece of advice, I'm not the lawyer on the show, but I would give this, is that if, sometimes when we meet someone in an interview and then we meet someone else, they could have similar qualifications. We just get this sense from one person or another, rightly or wrongly. Okay. I'm not judging that part of things. We really need to learn how to articulate that. What is going wrong? Like maybe someone was a few minutes late. Maybe they weren't listening when we were talking to them, and they were kept asking a ton of questions that didn't seem relevant. We need to note these things down and have them as evidence, and then find a way to make sure we're submitting those notes to whatever system we've employed to support this process.
And you know what? And some people would say we have to also educate ourselves about our unconscious biases, because quite often we feel most comfortable with people who we share something in common with, right? Maybe they've gone to the same school, or they've done the same extracurricular activities as we do. Maybe our children are in the same hockey team. And so we have a sort of a sense that they're part of my community. I'm comfortable with them. I can deal with them. And then you have someone who might be neurodivergent, or who may be a newcomer, and we don't share as much in common with them. And so we sometimes overlook objective excellence because of those. So maybe one of our topics can be, maybe not with me, maybe with a psychologist, about sort of all our unconscious biases, and how do we, create systems. We're never going to eliminate it, but create systems which essentially help us be disciplined about our recruitment process.
These are all such excellent points. And maybe it will, in a perfect world, help us be aware of our own biases when we have to actually put it into writing. And the second thing I was going to say, because mainly our audience will probably be some other employment lawyers, HR. I'm not thinking that, and employers, but I'm not thinking a ton of people leaders are going to be on here listening to us. So I would say one kind of action to take if you're listening to this and you're in HR, it's like, how do I educate my people leaders or hiring managers about this? Because that is going to be a big job for HR to continue to do.
Well, you know what? I mean, just to use an example from Gowlings, and I think many of the larger law firms are doing this. We recognize that for women and newcomers, it was harder for them to get hired because typically, certainly when I was young, the hiring partners were all male, and it's what they were comfortable with. I had partners tell me, well, I will always hire a varsity athlete, even if they're a C+ student, because I know what it takes to be a varsity athlete. I know they have good work habits. I know they're disciplined. I know they can work in a team, et cetera, et cetera. And all of those issues, discipline, hard work, being able to work in a team, are important attributes for a lawyer. But I don't think being a varsity athlete is necessarily the only indicator. So we did a lot of work in what we sort of said, unpacking excellence and looking for excellence elsewhere, unconscious bias training. But we also renew the training every time we start. Just a little refresher, so that we're forcing, especially when you have such fields of great candidates, that we're really focusing on things that we can articulate that people need to excel in this field. And is it perfect? Absolutely not. Is it better than what we were doing in the 1980s when I got hired? Absolutely.
Well, listen, someone's doing something right because you got hired, which was
That's right.
they made a really good choice there. Well, yeah, this one, like I said, it sends shivers down my back thinking about how to manage all of this. I can see why it's the right thing to do, but just because it's the right thing to do doesn't make it the easy thing to do.
No, one of our friends mentioned that some of the platforms that you use, like Indeed and LinkedIn, does a lot of that document retention. Just make sure you keep up your license with it, because people do shift from one platform to the other. And then when you move from one platform to another, how do you download all that information? Or perhaps even keeping that license for record retention purposes only, because you need to have an easy way. So just keep, it's just a question of paying some attention to it. So I have a homework list, and for January and February, my homework is making sure we're complying, especially in Ontario, but also in BC, with the pay transparency and the new rules of engagement on recruitment.
Okay. Do you mean you have a homework list for our audience, or you have a homework list for you?
Well, I think it's sort of the same, actually, but I
Yeah.
can share my homework list if you think it's
Yeah.
useful. Amy, I'll send it to you. And it just gives
Okay.
you some ideas of special projects you might want to think about, in addition to all
Yeah.
the other work that we have to do, from January to December.
We'll make sure that your email address is in the show notes, Neena. So what we can put in the notes to download, we will. And if you have questions for Neena, you can always reach out to her by going to the show notes and emailing her, or just going to Gowling WLG's website, and you can look her up as well. Outplacement and career transition support make a real difference for employees experiencing terminations or layoffs. Offering these services also reduces legal and reputational risk for employers. All of First 30's outplacement programs include access to a live coach, along with 1 year of access to our career transition portal, job search resources, and much more. Programs start at $985 per participant. You can find information about our programs and pricing at first30ready.com/outplacement, or reach out to us anytime at info@first30ready.com. Okay, what is our next topic?
So the other thing that, return to work in the
No,
office.
don't say it. You've told me that before. Don't say return to work.
Yes.
That's wrong.
It's return to office. So,
Yeah.
because I think 2020 and 2021 proved that with the right technology platforms, a lot of what we we can do remotely. I was talking to a client who in the old days would have had to go to the Caribbean or the UK to do certain work with certain regulators, and now it's done all remotely, and it could be done from her house or it can be done from her office. So we have expanded our ability to do certain kinds of work. We're now, however, seeing many, many employers feel that they lose something. There's a whole controversy about whether this is just management trying to, exercise unreasonable control or whether or not it's just a way of creating sort of that morale and team building, which is very hard to do on a, completely diffuse basis. And I'm not here to tell you what the answer is for your workplace. We just full disclosure have a 3 days in, 2 days out. We're pretty flexible about it. It seems to work. Is it perfect? Talk to management, they'll tell you. But I'm here to talk to you about some recent case law about return to office. First of all, for those of you who want to have the flexibility of requiring employees to come in, you have to be very careful that remote work hasn't become a condition of employment. Either doesn't and conditions of employment don't have to be in writing. They can actually be
Mm.
informal. And there's a small claims court decision called Bird and Welcome Home. And it's a 2024 decision, but it's a really well written decision. You have somebody who was working in person. Her husband gets posted to Belgium. They love each other. They said, well, we think we can make it work remotely, even with the time difference. Things start to not go as well. The employer realizes that they want somebody who can be at least in office, in the workplace for some period of time. They essentially start making those changes, and the judge finds, well, that's a constructive dismissal because you kind of promised she could work from Belgium.
And just I want to just stop you right there because there may be some people who don't know what constructive dismissal is.
So, constructive dismissal is a concept which says the employer did not actually fire the employee, but the employer unilaterally changed the terms and conditions of employment to the detriment of the employee, such that
So it
it
made
was
it
equivalent.
impossible.
Yes, it's
Right.
equivalent of
Yeah.
a termination. So it has to be a major term. Now, when we started with constructive dismissal, we used to talk about compensation because we're all interested in what we're making. So money and the method. Is it a salary? Is it commission? Is it contingent? Is it guaranteed? So that's the start of the discussion. Then judges said, well, location can matter. Are you going to be posted in Montreal or Toronto or Chicoutimi or Halifax? I mean, our lives are based on a geography. And much as I love, my firm, it would be a huge disruption if they suddenly said, well, we need you to move to Calgary. Like you can sort of see that. And the in office, work from home dichotomy, because people have lives, they have childcare, they have daycare, they have commutes, the expensive commutes, has now become a locational issue. So if you are wanting to say, yeah, we want people to experiment with that mix, but I want the right to call them back if it's not working out. I want to be able to look at people with the whites in their eyes, if you will. I want to be able to have team meetings in person. I don't want people to turn their cameras off. I don't know if they're there. If there's a drop in productivity, I want to know if the person's trying or if they're out doing their laundry. And so I want to bring them back in. And so that can become a constructive dismissal. So there's a whole bunch of work that you can do in your employment agreements and your policies to make it clear what your expectations are and what rights you're reserving. Now, I have tech companies that are remote first. They say, look, if you're not working out, we'll deal with it, we'll manage it. We have other companies that say work from home is a privilege and not a right. So just be careful how your company frames the in office work from home component so that you have the rights you think you want. In the welcome home case, I'm sure the employee thought she had the right, or employer thought she had the right to do what she was doing and was quite surprised by the result.
Yeah, that it's such a complex issue, and I'm pleased to say that we just decided before we hit record on this episode that one of our next episodes is going to be on employment agreements and terminations. So we will be going into employment contracts in a lot more detail soon. So stay tuned for that.
And
For sure.
subscribe, right? And send
Yeah.
us ideas, because we always like ideas, right?
Well, yes, we do. Return to office is just such an emotional, it's emotional. It's about what's possible for me. And I, was a single mom of 2 small kids, working in an office setting. And I'll tell you, I always hated getting to the office because it was such a chore. Oh my gosh, dragging 2 little kids to before school care. They made the joke that there was always lines in the snow for their 2 little, because I was just dragging them along. But I'll tell you, when I got to the office, I did love being in the office, and I formed relationships that are still alive today that I never would have got so close to people. And the laughter, oh my gosh, you can't trade. Just the jokes that happen in the office, you couldn't even explain to someone else.
I agree. I mean, I love where I work. You've met some of my colleagues.
Yes,
Amy,
I love where you work too.
There's a lawyer who whistles and a lawyer who hums and sings, but it's also the serendipity of conversations, particularly for my younger colleagues, because I'm always available by the phone, or you can do a Slack or a Teams. But the reality is my younger colleagues will not contact me about a file that is not related to my practice. They just won't. They will feel guilty about it. But if they catch me on the way to the coffee machine, going to the coffee machine, making your coffee, waiting for the, machine to stop blowing its steam and coming back, we can actually have a very good conversation. And that opens up another conversation. And that serendipitous conversations, those are harder to have when we have a remote first workplace. And how you replace that, I don't know.
I do love that you brought up coffee on a Coffee and Law podcast. Yes. So well done for that. But I have a fun little mug today that will introduce our next little segment, which is Spill the Tea. So at the end of every episode, we're going to have a little Spill the Tea segment where you can tell you had that presentation a few years ago, Tales from the Crypt or whatever it was. Yes. So like a shocking story, a bit of a horror story, a little bit of fun, something you can talk about. So is there any good story that you want to share so we can spill the tea together to close things off?
So I'm going to tell a story about how a conversation can lead to real problems. And so you have somebody who's coming in late and missing a lot of work, and the frontline supervisor is really irritated and hears via rumor that the person has some personal issues. So he has a conversation about, I need you to come to work, and your absenteeism is bad and this can't continue. But and the person starts to saying, well, I'm having some problems at home. And the supervisor is in a bad mood and says something to the equivalent of, your home life is your responsibility and not my problem. You need to smarten up. And then the person continues to have some absenteeism problems and is fired. That one conversation, which, that comment about your home life is not my problem, ended up becoming a huge human rights problem. Because if you'd unpacked that, you would have found that the person was going through a very difficult time, that their wife was ill, and that childcare was an issue because they didn't have a network of family people. And really what this person needed was just a little bit of time to get their act together. And when we looked at that problem, what we realized, HR had been trained and senior managers had been trained, but the frontline supervisors had not been given the tools to open up discussions about these things. So like, many people, oh, well, that's messy and personal. I don't want to discuss it. My job is to make sure you show up at 8:30 for your shift, right? That's my job. I don't want to deal with all the mess stuff. So the horror story is it ends up being a big check that the person has to write, the employer has to write. But the learning from that, Amy, is that when you're doing training and you make somebody a supervisor, people, even if you have beautiful policies saying, please talk to your HR business partner, please talk to the manager of your department. The frontline supervisor represents the company and they need the training as to how to open up a discussion. In this case, it was really family status and family care responsibilities. In another case, it could be drug and alcohol substance use issues. So you need to train that front line person. So if there's one thing you take away from this conversation is when you're looking at training people, train the people who interact the most with your frontline workers, train your supervisors, because if they can't deal with difficult situations, then what happens is eventually gets unpacked and it becomes a legal problem and it becomes very expensive.
And here is a great case study that they can put in the training that they offer. Right?
Yeah, and we can admit, like I do training, as you know, Amy, and I often am inspired, and I change the names to protect the innocent, of course.
Of course.
But I'm often inspired by the friction points that the frontline supervisors share with me.
Yes, I can only imagine. And, part of me, I'm not saying that I'm not taking a position at all, but it's like, we're all have those days where it's just like, I don't care about this right now.
It's not my problem, but it is your problem.
Exactly. It is your problem. Absolutely. Like as a parent and you're a parent, some days that's something you would say to your kid, like, I can't deal with this right now. But I know that it went further than that. And there was probably much deeper situation there. But yes, you never know. And especially today, you never know who's recording. In Ontario, I don't think a lot of people realize this. It's unlikely you're allowed to record conversations in your workplace. You would know more about that, Neena, than I do. But it's actually legal for it to be a one-sided recording
in Canada.
In Ontario.
In Canada.
In all of Canada.
I think it's in all of
that.
Canada. Always accept Quebec out of that because it's a criminal code provision to record a conversation to which you are not a party. But if you and I are having a conversation and I record it, it's not a criminal code issue. Now, some employers have put in policies about recording in the workplace, but that's another coffee and law discussion, I guess.
I think so too. And I just want to clarify what you said there because you talked about it quickly. So if you are not part of a conversation, so if you're eavesdropping or you've come onto a call that you're not supposed to be on and you're recording two people speaking and you are not part of that dialogue, that is illegal. If you are part of the dialogue and you're recording, that is can be admissible in court.
Absolutely.
Yeah.
So I think we're like close to time, Amy. Where has the time gone?
I know. It moves so fast. And I know I apologize to everyone when you think of everything changing in 2026. We just scratched the surface, but we wanted to make sure that we brought up some really important topics that HR and employers need to plan for. Like Neena said, you can reach out to us about different topics that you'd like us to cover. We're always happy to hear from you. And you can I'll make sure that I put both of our email addresses in the show notes. And if there's any resources that Gowling or Neena can share, you will find those there as well. But Neena, thank you. I thought this was amazing. I know that it's going to give people a lot to walk away with. And I'm so excited to continue this series.
Well, thank you, Amy, for thinking of me and inviting me.
Well, have a great day, everybody.